If the appeal progresses to a formal hearing, it's highly recommended that you find an attorney to represent you in the complex legal proceedings. Again, the BIIA will not provide one for you. You can find a listing of attorneys specializing in workers' compensation in the Yellow Pages. Attorneys will often work on a contingency fee basis, meaning they will be paid a percentage of any back benefits awarded. To help your case through the hearing, you should make copies of records, letters, or other materials for all the parties, including the judge. Remember, none of the evidence presented in the mediation conference or discussions with the mediation judge will be available at the hearing. You'll need to introduce all your evidence at the hearing. You'll have to make or respond in writing to any pre-hearing motions prior to deadlines indicated by the BIIA. You'll receive a notice from the BIIA with very important information regarding your hearing. The BIIA's notice will inform you of the name of the hearing's judge. You will have to attend a scheduling conference arranged by the BIIA. This is where you will submit a witness list, so bring it with you. The hearings judge may issue subpoenas for a witness to appear. In nearly all cases, your doctor or medical provider will need to testify in person. You will have to pay for any witness fees that your doctor, medical provider, or others might charge. During this time before the hearing, you will be able to learn what the opposing party's evidence will be. Likewise, they will know what your evidence is. This is called discovery. L&I may request copies of your evidence for this purpose.
Well, the hearing process operates just like a court of law. It is a formal process. This is not a place where I would suggest to a worker, for example, to go in without an attorney. The Attorney General's office is there. They're representing the department's order. An employer oftentimes has an attorney representing them. So it's a place where it's formal. They're looking at evidence. You're calling witnesses. You want doctor testimony. You have to have good knowledge of the facts of the case and of law.
The atmosphere at the hearing is much different than it is at the mediation process or at any other stage of this process. It is more formal because evidence is to be presented under oath, because there are only certain kinds of questions a party can ask that are legitimate, that can be asked of people, and because the other side has the right to object, and then I have to make a ruling. At a mediation conference, for example, if a worker says something and the other party doesn't believe that's true, the other party doesn't object and move to strike whatever was said, because they're there to find out what's on each other's minds. At the hearing process, questions need to be asked of the witness. A witness is not allowed simply to come in and start speaking without any question being before them and going on without any check. They have to respond to questions that are asked of them either by the worker or by the attorney representing the other side.
After the hearing date is set, a litigation order will be issued. This is a fact sheet with all the important information about your upcoming hearing, including the date, location, name of the hearings judge, witnesses, and important deadlines.